51, which has been read. Mr. Chief Clerk.
Mr. Speaker, engrossed House Bill 1451, introduced by Representative Casper and other House and Senate sponsors. Engrossed House Bill 1451 is a bill for an act to amend and reenact sections 29-10.1-02 and -21 and -22 of the North Dakota Century Code relating to the requirements for calling and the duties of a grand jury. Mr. Speaker, this has a fiscal note prepared by the court system on January 22, 2013. Their analysis indicates no fiscal impact. Mr. Speaker, your Judiciary Committee recommends amendments which were passed on the previous sixth order. When so amended and engrossed, recommends do pass on engrossed House Bill 1451 by a vote of 9 yeas, 5 nays, 0 absent, and 0 not voting. Mr. Speaker.
Representative Brabant.
Mr. Speaker and members of the Assembly, your Judiciary Committee recommends passage of House Bill 1451 as amended. House Bill 1451 is a bill that seeks to bring the grand jury structure into harmony with the modern criminal justice system and has the support of the North Dakota Association of Counties as well as the North Dakota State's Attorneys Association. There was no opposition as far as testimony was concerned in the committee. Currently, the grand jury process has not been modified in 42 years. Additionally, many of the grand jury concepts have origins that date back to 1877 under the revised codes in the Dakota Territory. The federal government's use of grand juries dates to the Bill of Rights and is currently the method by which to bring charges against all defendants in federal court. This lack of modernization has left the grand jury process somewhat irrelevant and seldom used in North Dakota state courts. In fact, the representative for the North Dakota State's Attorneys Association has labeled it essentially useless. Modern criminal practice has evolved through court rules and other statutorily authorizations which prosecutors can initiate charges against a suspect without resorting to the use of grand jury proceedings. However, for many years, state's attorneys and assistant state's attorneys have considered requesting the legislature revamp the grand jury chapter to make it more usable. House Bill 1451 is the result of those efforts. Section 1 of the bill makes clear on the county level it is the state's attorney who is entitled to call the grand jury and not the county commission. State's attorneys are the only county officials with the statutory duty to bring actions in criminal court to enforce state law. County commissioners lack such statutory authority and their placement in the grand jury system is outdated. Section 1 also adjusts the threshold of the required amount of citizens' petitions to request a grand jury. Under current law, by only requiring 10% means in certain counties simply having 45 people sign a petition would result in the calling of a grand jury. Such a minimalist requirement could allow the criminal justice system to be abused and subject innocent people to criminal charges. Section 2 of the bill removes the most confusing language of existing law. The struck language is inconsistent with the current criminal justice system. The new language defines the parameters of how the proceedings are to be conducted and which cases are subject to the proceedings. Section number 3 of the bill deals with the old language but seeks to clarify grand jury proceedings are appropriate in cases of investigating felonies by officials and other misdemeanor crimes can be conducted in the normal criminal process. This bill keeps the citizen grand jury process. Only a few states have the petition provision and the feds do not have it at all. Under North Dakota Century Code 11-16-06, citizens already have the option of asking the district court to review the state's attorney's decision. In visiting with a third-year UND law student, he informed me that because I was questioning him about certain aspects of the grand jury, before I got involved in this process a couple of weeks ago in committee, I didn't know very much about a grand jury. I know a little bit more about it now, probably more than I want to know. Anyway, he informed me that the joke around the UND campus is you can indict a ham sandwich. So, anyway, in addition to that, I happened to receive a phone call last night from a very concerned citizen. I talked to him for about an hour and a half on the phone. He was, I would call it extreme persuasion. Anyway, he did most of the talking, I did most of the listening. Anyway, he, towards the end, just before he hung up, he said, I'm going to pray for you. He got my attention. So he hung up the phone, and I got to thinking, and after a few minutes of thinking about what he had just told me, I countered with a prayer of my own. Once I got that out of the way, it kind of cleared my conscience. So I hope we get a green vote on this bill. I think it's a good bill. It's the grand jury is termed useless by individuals. There are different duties and functions of a grand jury, which I learned all about, including checking the conditions of the prisons, investigating misconduct of public officials. Basically, their two functions are to investigate and to indict. We have, I think this about covers it, I think. We do have a 40%, what am I doing wrong here? Am I rocking again? Anyway, I should close this by asking for your green vote, and hope you concur, Mr. Speaker and members of the Assembly. I would hope that you would pass this with a green vote.
Is there any discussion? Representative Ammerman.
Thank you, Mr. Speaker. Would the bill carrier yield to a question, please?
Representative Brabant, would you yield to a question?
Mr. Speaker, I will.
Representative Ammerman.
Thank you, Mr. Speaker, and Representative Brabant. You mentioned several times that some lawyers know that this is kind of a useless process or whatever, but now we're going, instead of 10% of the vote to have a petition, we're going to 40%. So are we making a useless thing more useless? Because it's going to be harder to do?
Yes, we are.
Is there any other discussion? Seeing none, excuse me, Representative Mock.
Thank you, Mr. Chairman. Mr. Speaker, will the bill carrier yield to another question?
Representative Brabant, would you yield to another question?
Mr. Speaker, I will.
Representative Mock.
Thank you, Mr. Speaker. Representative Brabant, where else in statute do we require 40% of the people who had voted in the last gubernatorial election to initiate any process?
Nowhere.
Mr. Speaker, may I continue?
You may continue, Representative Mock.
Will the bill carrier yield to another question?
Representative Brabant, would you yield to another question?
I'll allow a takedown, but not a pin.
Representative Mock.
Thank you, Mr. Speaker. Mr. Speaker, Representative Brabant, what is the process to recall an elected official?
Currently, an elected official can be recalled with a 25% of the vote cast in the county for the last gubernatorial race in the last general election.
Mr. Speaker, I continue?
You may continue.
Will the bill carrier yield to another question?
Representative Brabant, would you yield to another question?
Quite possibly.
Representative Mock.
Thank you, Mr. Speaker. In Section 3 of the bill, we are changing the allowance for the grand jury, whereas current law it says willful and corrupt misconduct. Now we're adding felonious to the section. So now a grand jury can only be convened to investigate corrupt felonies. And I have to ask Representative Brabant, what is a corrupt felony?
Representative Brabant.
I would call that verbose. A felony. It was changed to corrupt and felonious. No, I don't know what it was called.
Representative Koppelman, would you care to respond?
Thank you, Mr. Speaker. I will. I won't ask Representative Mock a question, but I could. And my question would be, how many public officials have ever been charged with corrupt practices in North Dakota by a grand jury? I haven't researched that, but my guess is the answer would be none. And the amendments in this bill, especially the ones that are being spoken of now, came to us at the suggestion of the North Dakota State's Attorneys Association and the Association of Counties. I hope that answers your question. I'll continue with other information.
Mr. Speaker, may I continue?
You may continue.
Will the committee chairman yield to a question?
Representative Koppelman, you yield to a question.
Mr. Chairman, I will.
Thank you.
Speaker, I'm sorry.
Thank you, Mr. Speaker and Mr. Chairman. My question is what is a corrupt felony?
I think it would apply to any felony in law. I don't think the modifier of the word corrupt would, I think any felony would be considered corrupt. So I think the insertion of the word felony simply means that it would be to indict for a felony crime.
Okay. Thank you, Mr. Chairman. Mr. Speaker, may I continue?
You may continue.
Mr. Speaker and members of the Assembly, and I understand that this is a section of law that right now only 5 states across the country have this process, 2 of which protect it in their constitution. So this is something that even North Dakotans have embraced and have kept on the books as a relative and appropriate power for the people to provide accountability over their elected officials. In 1890, this act was actually put in the books to allow for for petitioners or citizens to convene a grand jury by collecting 25 signatures in that jurisdiction. In 1905, it was amended to be 10%, so that the citizens with 10% of the population who had voted for governor in that last election, they could convene a grand jury to investigate willful and corrupt misconduct of any elected officials. Now, I want to point out something to the Assembly, that the section of code related to corrupt practices are all misdemeanor offenses. That paying somebody to vote is a misdemeanor. That paying for a newspaper to endorse or oppose a candidate is a misdemeanor. That many of the actions that this section of law can apply to are misdemeanors. In fact, the point is that a corrupt felony, there are very few corrupt felonies in our books. Corruption is defined in law, but there is very few examples of a corrupt felony, essentially rendering the power of the people to convene a grand jury useless. That if there is an act of misconduct, they do not have the ability to convene a grand jury because most of those penalties are misdemeanors. Furthermore, there is only one section in law where 40% is required to convene anything, to initiate any action, and that's to affirm the city manager plan of a subdivision. It's the only place in code where 40% is the threshold. It takes 10% of a political subdivision to move the county seat. So it's actually easier, if this passes, to relocate the head of a county than it would be to investigate misconduct. Mr. Speaker, and as the bill carrier had alluded to, the current law has not been onerous and has not led to very few investigations. Raising the threshold to 40% renders the power of the people to investigate misconduct or to convene a grand jury useless. We just as well remove that ability and say that they do not have such authority. So, Mr. Speaker, members of the Assembly, I certainly hope that we can adhere to the spirit of Article 3 of our Constitution, reserve powers of the people, reject House Bill 1451, because it does not answer the challenges that have been brought forth to this Assembly. There is nothing in here that makes this a more relevant section of law and helps enhance the power of the people of our state. In fact, it does the opposite. It does the contrary. It makes it difficult, and it only takes away more power of the people that we represent. So, Mr. Speaker, I certainly hope that we can reject House Bill 1451. Thank you.
Representative Ruby.
Thank you, Mr. Speaker, members of the Assembly. I'm against this bill for many of the reasons that Representative Mock just mentioned. In the past, I, along with the chairman of the committee, worked on some improvements to our Corrupt Practices Act. I think that this does a few things. I have some problems with that 40%, but then we also include a cap on the number, which I think sets a different precedence and a different level depending on the county you're in. I think that's a wrong way to go about it. On line 15, under the state's attorney can already call one. This is about the people and using the county commissioners as their avenue to get this process going. I think going through the state's attorney's office, which is already able to do this, is not very good practice. So I would encourage a red vote. Thank you.
Representative Kay Koppelman.
Well, thank you, Mr. Speaker, and members of the Assembly. Would Representative Mock yield to a question?
Representative Mock, would you yield to a question?
Mr. Speaker, I will.
Representative Koppelman.
Thank you, Mr. Speaker. Representative Mock, I'm just wondering from your comments earlier, what is the primary purpose of a grand jury in your estimation?
Representative Mock.
Mr. Speaker, Mr. Chairman, I'll read you the purpose of a grand jury. 2910.1 says that a grand jury must consist of not less than 8 nor more than 11 persons of the county possessing the qualifications of jurors prescribed by law, and the impaneled and sworn to inquire into all crimes and public offenses against laws of this state, triable within the county, and, if the evidence warrants, presents them to a district court by written indictment.
Representative Koppelman.
Thank you, Mr. Speaker, and Representative Mock. May I continue?
You may continue.
Thank you. Mr. Speaker and members of the Assembly, I read the entire chapter on grand juries this morning as this bill was coming before us. The bill deals with a very small portion of that chapter, and I think it's important. First of all, I want to commend the subcommittee, which Representative Brabant chaired from Judiciary. They did an excellent job in this bill. There seems to be a lot of peripheral discussion about this issue. And I'm very pleased that I knew nothing about any of that discussion or any circumstances or any issues prior to this legislative session, and I still don't know much, prior to this bill coming before us. But I will say this, the grand juries are used in the federal system almost exclusively, and their purpose is to indict people for criminal activity. Our lieutenant governor presiding across the hall in the Senate was once a federal prosecutor. The purpose of a grand jury primarily, and as Representative Mock just indicated, is to bring criminal charges. Now, there's a minor part of our statute that deals with something else that has occupied most of our time and attention this morning in talking about the bill, and that's unfortunate because as a Judiciary Committee and as a Legislative Assembly, I believe what we need to do is when a bill comes before us, we need to evaluate that bill. We need to look at what current law says on a particular issue, what a bill intends to change in that current law, and what is the best public policy for the state of North Dakota. I'm extremely proud of the fact that the Judiciary Committee was able to do that almost in a vacuum, without any of this peripheral business going on. And what we looked at, ladies and gentlemen, and I would beg to differ slightly with some of the comments that were made earlier, because our investigation shows that actually this dates back to territorial days. Not 1890, I believe the state became a state in 1889, and I think it was prior to that, even territorial days, that some of these things were on the books. And the question, I want to address the threshold question, because that's something our subcommittee worked on very, very hard. The bill as it came to us required 25% of the population of a particular area to call for a grand jury. A petition signed by 25% of the people, men, women, and children. Every other provision that I know of that we have in law regarding petitions requires a percentage of the people that voted for governor in the last election, as does the current statute. So one thing the subcommittee did was make that change. The second thing the subcommittee did was to take a look at the threshold required. Under current law, as was said, it's 10%. Now, it takes 25% to signing a petition to recall any one of us in this chamber. Should it take fewer people to threaten your job than it does to threaten your freedom? The purpose of a grand jury is to be impaneled to investigate criminal activity and to potentially bring an indictment. Should there be fewer people that are allowed to do that compared to the number of people that are simply allowed to sign a petition, to force an election, to question whether you should stay in office or not? Our committee thought not, and I think our committee did good work. Ladies and gentlemen of the Assembly, the fact of the matter is the grand jury system is seldom used in North Dakota. I don't know if it's ever been used. I haven't done that thorough a search of history, but certainly in recent history, it's seldom been used. Some of the antiquated things that the committee dealt with that I think are important, if you look at the bill, the original law talks about the purpose of a grand jury being to see if people were falsely imprisoned. In other words, if they're locked up and there's no charge brought against them, the grand jury can be created to bring a charge. Well, that's not necessary under current law. With constitutional rights and the way our current system works, it's not necessary. The current bill called for county commissioners to do this. And the Association of Counties came in. Mr. Burst, representing the North Dakota State's Attorneys Association, they said this is silly. The county commissioners have absolutely nothing to do with our criminal justice system. That's a court process. So now the bill is amended to say the grand jury can bring their recommendation to a state's attorney who can bring those charges. Those are our prosecutors, folks. Those are the people that do that. Or they can bring it to a judge who can do it. And by the way, it's not optional. If a grand jury is impaneled, if a petition is signed to impanel a grand jury, it's mandatory. But I want to say one more thing. In the last 2 days, I've received reports of threats, intimidation, and innuendo against members of this assembly over this piece of legislation. And I will defend every member of our committee and every member of this assembly, Democrat, Republican, right, left, east, west, urban, rural, I don't care. I'll defend any of you of the right that you have, know the responsibility that you have as elected members of this assembly to stand up and look at legislation and do what you think is right, without fear, without threat, and without intimidation. I think the committee's done good work on this bill, and I ask for a green vote.
Representative Kretschmar.
Thank you, Mr. Speaker, and ladies and gentlemen of the House. I too agree that this is a good bill and that we should pass it. The current law on grand juries is an old law, and we should look at these laws every once in a while to see if they need revision. And this law, we thought in our Judiciary Committee, needed some revision. And the current law, a grand jury can be called by the judge of a district court with jurisdiction in that county. And these are grand juries called in our various counties. And now under the current bill, the state's attorney would also have that responsibility to call a grand jury if they wish. And the committee decided that the number of petitioners to get the grand jury called should be increased so that power of the people is not really is put to a good purpose and not used just for some kinds of purposes that aren't maybe so good as some people think. But, you know, with those conditions in there, the grand jury can investigate any criminal activity in the county, whether it be felonies or whether it be misdemeanors. If it's a criminal law, the grand jury can look at it. And the bill came in with some indications to look at the corruption of elected officials, and that is good. So I think basically this is a good revision of our grand jury system, even though our grand jury system is really rarely, if ever, used. I've been a practicing lawyer in North Dakota for more years than I want to admit, I think, and I've never heard of a grand jury being used in my area of the state or in any area of the state. Generally, the criminal laws are subject to the jurisdiction of our state's attorneys in the various counties, or to our attorney general in some instances, and their people are brought into court by information by the state's attorney, and then there can be preliminary hearings and a trial as time goes on. A grand jury would have that power too, to indict people, and then they would be brought before the courts, and the criminal process in North Dakota would proceed. So I think, Mr. Speaker, and ladies and gentlemen of the House, we've had a long debate on this bill. I think it is a good revision of our current law, and we should keep it and pass the bill.
Representative Brabant.
Thank you, Mr. Speaker. If we're talking percentages, let's talk percentages. If you have a grand jury of a minimum of 8 jurors and a maximum of 11, it still takes 6 to hand down an indictment. 6 out of 8 is 75%. That's what it is.
Are there any further discussion? Seeing none, Representative Ammerman.
Thank you, Mr. Speaker, and I'll try to make this quick. I didn't realize that one opening question of mine was going to open up so much discussion. But still, the troubling part to me is the 10 to 40%. Now, it's been said several times in here at the 10%, this is hardly used, or maybe hardly ever been used. So now if we go to 40%, it's not only be hardly ever used, it won't be able to be used, basically, because, and it's not just 25 or 40% of men, women, and children. That's not how it works. You have to get 40% of qualified electors. So you have to get 40% of the people qualified to vote to do this. That's not just counting families or anything. So I have a hard time trying to understand why we take something that's hardly used, and now we're going to make it so it's never used, but we're still going to keep it on the books. But anyway, this needs to be killed. Thank you.
Is there any further discussion? Seeing none, the House has before it for final consideration House Bill 1451. The clerk will open the key and you may record your vote. Has every member voted? Does any member wish to change their vote? The key will be closed and the clerk will take the record. Final vote shows 61 yea, 33 nay, 0 absent, not voting. House Bill 1451 is declared passed. Continuing on 11th